Hello and welcome. Thank you for being here for UC Davis Law's Racial Justice Speaker Series event with Duke Law Professor Veronica Martinez. I'm Carla Meyer from the Communications Office at the School of Law. I want to get to a few things before we begin. This event is being recorded and the recording will be available within the next week. Also, MCLE credits will be emailed to everyone within a week. At the end of Professor Martinez's talk, there will be a brief question and answer session, and I would like you to please send your questions directly to me through the chat function, Carla Meyer. And I just want to let you know that everyone except the speakers will be muted during this event. And now I would like to turn things over to UC Davis Law's Senior Associate Dean for Academic Affairs, Afra Afsharipour, who will introduce Professor Martinez.
Thank you, Carla. Hello and welcome. I'm Afra Afsharipour, Senior Associate Dean for Academic Affairs at UC Davis School of Law. Thank you all for being here and being with us on Zoom. Today's talk by Duke Law Professor Veronica Martinez caps off this semester's Racial Justice Speaker Series program, which will continue in the spring semester. Created in fall 2020 in response to the tragic killings of George Floyd, Breonna Taylor, and others, this series began as an examination of the alarming racial inequities within the U.S. criminal justice system, but it has quickly grown into an exploration of the effects of systemic racism, both overt and quietly insidious, on all areas of the law. The series has featured some of the finest legal scholars and practitioners of our time. Our speaker today continues that tradition. Professor Martinez is one of the nation's foremost experts on corporate compliance and is the nation's leading academic expert on the role of monitors and monitorships. In her scholarship, Professor Martinez has investigated the institutional mechanisms that organizations can utilize to promote ethical norms within professional and organizational environments, improve long-term compliance with legal and regulatory requirements, and to encourage the development of diversity and inclusion norms. She has published or has work forthcoming in many leading law journals, including the Harvard Law Review, the Columbia Law Review, the Cornell Law Review, and the Virginia Law Review, just to name a few. Her new book that is forthcoming with Edward Elgar is entitled Building an Effective Ethics and Compliance Program. Professor Martinez is also a sought-after speaker on issues related to ethics and compliance initiatives at firms, as well as on diversity and inclusion efforts. She's joined the Duke Law faculty in 2022 from Notre Dame Law School, where she was a professor of law, the Robert and Marion Short Scholar, and director of the program on business ethics, compliance, and inclusion. Professor Martinez was the first Black woman to receive tenure at Notre Dame Law School and the first Black woman to be internally promoted to full professor at Notre Dame University. Currently, in addition to her appointment on the Duke Law faculty, she holds a secondary appointment in the Fuqua School of Business in the Management and Organizations area. And outside of Duke, she's currently serving a 4-year term on FINRA's National Adjudicatory Council. And prior to her teaching career, she was a clerk on the U.S. Court of Appeals for the Fifth Circuit and an attorney at Gibson Dunn in Washington, D.C. after her graduation from the University of Chicago Law School. In her talk today, Building a Culture of Ethical Inclusion, Professor Martinez will address how two social movements, the Me Too movement of 2017 and 18, and the Black Lives Matter movement in 2022, forced corporate firms to rethink how to approach the status of women and people of color within their organization, and to think more deeply about improving demographic diversity and true inclusion within the upper echelons of their organizations. She will argue today that in addition to pursuing the business and legal cases for diversity when crafting DEI programs, corporate firms should also employ the ethics case so as to create a truly inclusive organizational culture. Please join me in welcoming Professor Veronica Martinez.
Thank you so much, Afra and Dean Johnson, for inviting me to come today to speak with you. It is an honor to be a part of such a distinguished speaker series, and I'm deeply humbled to have been given this invitation and to be able to contribute to the important conversations your law school community is having. The project we are going to discuss today is around how organizations can build a culture of ethical inclusion. I say organizations on purpose. The examples in this project are centered around corporate actors, but the basic idea and thrust could be applied to a variety of organizations, and that would include the legal profession and law schools. So I want to encourage you to think how you might apply the principles I outlined today within your organizational structure, the place that you live right now. Your first question, I think, is what do I mean by the phrase, build a culture of ethical inclusion? When I focus on a culture of ethical inclusion, I am concerned about how organizations can create cultures where people of diverse demographic groups and varied belief structures are able to interact and work together while maintaining the inherent dignity of each person. I argue that we can only achieve such an outcome if we are willing to actively frame issues of diversity, equity, and inclusion as ethical issues, while also taking into account that we all sometimes fall short of acting in accordance with the ethical standards and values that we expect of ourselves and others. Today, I will start by outlining some of the origins of this project, which is the result of my work in the fields of ethics, compliance, and diversity, equity, and inclusion. I will then describe the predominant arguments that are put forward in support of DEI efforts today. So those are traditionally articulated as the business case or the legal case for DEI. I will then turn to concepts from a field called behavioral ethics to demonstrate why it is important to frame DEI issues as ethical issues and acknowledge how we sometimes fail to meet our own expectations of what ethical conduct should look like. I will then circle back and provide examples for why I think organizations focused on creating a culture of ethical inclusion must focus on three core components of any DEI program: diverse demographic groups, varied belief structures, and the dignity of each person. Excuse me. So the origins of the project. So I could give you a few different examples for how ethics, compliance, and inclusion intersect, even when we would traditionally think of things like legal issues. So on the sexual harassment side, I could give you the sexual harassment scandal at Fox News. On the racial discrimination side, I could give you a 2000 settlement at the Coca-Cola Company. So Coca-Cola in 2000 settled an employment discrimination lawsuit with Black employees. I should emphasize that they settled without admitting any wrongdoing. They did agree to pay $113 million to thousands of Black employees, and they spent around $43 million to adjust Black employees' salaries. I think a lot of folks would consider this a kind of standard legal issue. There's a violation of Title VII. There's a lawsuit, and the settlement is how they're addressing this legal problem. But for me, the Coca-Cola settlement and some of the activities at a bunch of firms post Me Too, where a lot of sexual harassment came to light, those settlements evoke thinking around the concepts of ethics, compliance, and inclusion. So let's take ethics. The allegation in the Coca-Cola lawsuit was that the Black employees were paid less than their white counterparts. From my view, it is unethical to pay a Black employee less money than a white employee because of their race. It's just not the right thing to do, just like it wouldn't be the right thing to emphasize certain components of one's sexual identity during the course of an employment setting. From a compliance perspective, the Coca-Cola settlement included a very specific monitoring requirement. So the settlement included that Coca-Cola put $36 million in reserve for programs to monitor the firm's employment practices going forward in an effort to stop future pay disparities. So they've put things in place so they won't have future issues like this down the line. And then from an inclusion perspective, if I know or suspect that I'm being disfavored by my employer because of my race or demographic status, or if I'm being subjected to harassing and demeaning treatment because of an aspect of my demographic status, I'm going to be less likely to be my true self within that workplace. On the racial side, there's a particularly good book called Acting White by Devin Carbato and Mitu Gulati that details the ways in which Black employees often felt like they could not bring their full true selves into the workplace, and that instead they had to project a different kind of, they had to project a persona that was going to be palatable to the overwhelmingly white workplace. These issues, these discrimination cases and these harassment cases, I mean, if you're a lawyer, you automatically think about the legal issues and ramifications, but it's often not that simple. There's often these intersecting issues of ethics, compliance, and inclusion. And thinking about these sorts of settlements from that perspective eventually led me to think critically about the ways in which corporate DEI efforts have been traditionally presented. So the predominant discussion of DEI efforts is usually couched in either the business case or the legal case. Scholars and leaders within corporate firms have long debated the best way to present DEI initiatives in a way that will obtain broad-based buy-in from those within firms. The arguments in favor of the business case for diversity have been articulated for over 25 years. For example, since the late 1990s, scholars have argued that the presentation of a solid business case increases the likelihood of obtaining the leadership commitment and resources needed to successfully implement diversity initiatives. They argue that firms were having difficulty meeting their diversity priorities and goals, in part because there were often more tangible and compelling business priorities that seemed more pressing for firms to invest their resources. As a result, scholars urge those at firms responsible for DEI programs to develop a case for diversity integration based off of the competitive edge gained by optimizing the people resources of a firm. So the business case, some think, ties DEI efforts to concerns about profitability as well as performance of the firm. A key component to business case arguments has been that investing in diversity will have long-term value, and they really mean financial value, for the firm. There are a number of studies supporting the argument that diversity does in fact assist in improving firm profitability, although I should note that many of these studies have been criticized by academics as not having sufficiently rigorous methodological components. A lot of the studies have been issued by consulting firms like McKinsey and other places, whereas academics have been more reluctant to embrace these studies. Despite the split on the empirical justifications and the long-standing articulation of the business case for diversity, many agree that there's a majority of firms that have failed to make meaningful progress on the DEI initiatives. For example, some management scholars argued in 2020 that organizations have largely failed to adopt a learning orientation toward diversity and are no closer to reaping its benefits. Instead, business leaders and diversity advocates alike are advancing a simplistic and empirically unsubstantiated version of the business case. They misconstrue or ignore what abundant research has now made clear. Increasing the numbers of traditionally underrepresented people in your workforce does not automatically produce benefits. Taking an add diversity and stir approach while business continues as usual will not spur leaps in your firm's effectiveness or firm performance. These management scholars make an important and powerful point. The business case for diversity, when translated into action within firms, often results in DEI programs that are overwhelmingly focused on recruitment of individuals who will improve the demographic diversity of the firm. Improving demographic diversity is incredibly important. I have argued in different articles that is in favor of initiatives that would improve demographic diversity at firms. But as scholars have suggested, a focus on demographic diversity, while a necessary component for a firm to implement a successful DEI program, is not sufficient on its own. The legal case for DEI programs is often rooted in concerns surrounding compliance with certain legal and regulatory mandates. And that makes sense when one reminds oneself of the origins of the diversity rationale within legal spaces. The discussion of diversity within legal spaces and case law find their roots in the push for affirmative action. The term affirmative action was first penned in a 1961 executive order issued by President Kennedy. The executive order created the Committee on Equal Employment Opportunity and mandated that projects financed with federal funds take affirmative action to ensure that employers receiving federal funds implemented employment practices and hiring procedures free of racial bias. The order was followed by the implementation of the Civil Rights Act, which was signed by President Johnson in 1964. And Title VII of the Civil Rights Act prohibits virtually all private employers from discriminating on the basis of a person's race, color, religion, or national origin. But President Johnson explained in 1965 that civil rights laws were not enough to remedy discrimination on their own. Instead, a concerted effort had to be made by society to give those members systematically oppressed a fair shake. He said, "We seek not just freedom, but opportunity, not just legal equity, but human ability, not just equality as a right and a theory, but equality as a right, as a fact and as a result." President Johnson's description reflects the belief that the extensive and deep-seated limitations on opportunity for persons of color in this country would not be remedied quickly or easily. And Title VII recognized the role that corporate firms needed to play to help combat discrimination within their workplaces and beyond. And yet, the Supreme Court has expressed severe skepticism of any sort of racial preferences. And less than 15 years later, in University v. Bakke, the court, when grappling with affirmative action within higher education, ended up embracing the diversity rationale for permitting affirmative action. That case, while not applicable to private employers, impacted the way private employers crafted their own anti-discrimination efforts. Private employers shied away from setting specific goals and targets with regards to their workforces, and instead used the less easily defined and more amorphous term diversity as the umbrella for their anti-discrimination strategies. But as Professor Cheryl Wade has argued, as corporate firms have moved away from the discussions of anti-discrimination efforts in favor of less concrete conversations about diversity, some of the punch of these efforts was lost. Indeed, she explains that implicit in corporate firms' silence about discrimination and racism was the conclusion that these problems had been resolved within their companies, if they had ever existed at all. When firms attempted to create DEI programs that would not run afoul of the rationale set in Bakke, the unintended consequence is that they stopped using explicit language related to anti-discrimination efforts. This changed matters for a whole host of reasons. But one in particular is that there is empirical evidence that suggests that the legal case for diversity is actually more effective than the business case. Professor Jamila Bowman-Williams conducted a study comparing the business case and the legal case. She found that the legal case, which focuses on the legal rationales emphasizing anti-discrimination laws, is more effective than the business case at reducing bias within firms. This is, of course, one study, but it does help cement the importance of firms to rely on the legal case for diversity when creating their DEI programs. But again, the legal case on its own is likely not enough to ensure a DEI program that meets all the goals and aspirations that firms say they want to achieve actually will happen. The legal case may, as Williams' study suggests, be helpful to eliminate bias within firms, while the business case may be important for getting buy-in from a large subset of an organization to participate in DEI efforts. In short, despite the competing rationales presented in an effort to support DEI initiatives, both the business and legal cases can serve important purposes. But these traditional rationales for DEI efforts, which have been around for a really long time, have not resulted in a transformation within corporate firms. And instead, it almost seems as if firms have maintained the status quo. I should note that the death of George Floyd created a transformational moment within corporate firms, unlike any that I think we've ever seen before. And part of that moment was that firms began to suggest that they were willing to do more with more specificity than they had done in the past. You did see a few firms implement particular targets. So I wouldn't call them quotas, but particular targets with regards to their diversity efforts, particular goals that they were attempting to achieve. And you saw much more explicit language within firms about their commitment to achieve racial justice and racial equity within their ranks. Professor Lisa Fairfax has a recent article out that suggests that this was not all rhetoric, and that there is reason to hope that the changes within corporate firms post 2020 have been significant and are starting to make changes within firms. That said, part of my project is targeted at looking at the business and legal cases and asking how might we reframe these conversations from an ethical perspective. And so I'm going to talk to you a little bit about two insights from behavioral ethics research that I think can be helpful to incorporate into our conversations about DEI within corporate firms. My examples are a little silly. You'll have to forgive me, but my hope is that they are pretty accessible. So the first example I have for you is that the hat you are wearing when you are facing a question or problem or decision changes the way you answer that question. This is a framing example. So my example is ice cream. So let's take something as innocuous as ice cream. Let's say someone asks you whether you think it's okay for them to have an extra scoop of ice cream after dinner. This isn't going to change the world, but depending on what hat you have on, you may change your mind. Let's say the person asking for more ice cream is your 2-year-old child. My 2-year-old would eat as much ice cream as humanly possible. I'm probably going to say no if he asks for another scoop of ice cream, not because it really matters, but because I don't want to teach him it's okay to eat copious amounts of different dessert. Now let's shift my hat from parent to caregiving daughter. My mom has had 2 major heart surgeries, and after the first one, she really needed to gain weight. She didn't have to ask me for ice cream. I was pushing it. I went to the store and found every possible ice cream flavor that I thought she might eat, and I bought all of it. There has never been so much ice cream in our house. But calories in. She needed to gain weight, and she was willing to eat the ice cream. So now imagine the person wanting the ice cream is my friend, and she asks whether she can have an extra scoop. I probably don't care. You're an adult. If you want more ice cream, have your ice cream. I don't feel the need to set a good example, and I don't feel the need to take care of you in the same way. So I feel no need to strongly advocate for or against the extra scoop of ice cream. I submit to you, I know the ice cream example may seem silly, but it illustrates the concept behavioral ethicists sometimes refer to as framing. How a question or problem is framed primes us and our response to that question. And we can reframe business and legal rationales in support of DEI as ethical questions. So first, let's reframe the business case. Let's assume that the fictional Acme Corp in recent years has embraced the research that suggests that diverse teams craft better decisions that bring greater profitability and value to the firm. Decision makers at the firm begin to look at strategies that will allow it to create more demographically diverse firms, and it begins to audit its most important internal committees and teams to ensure there is gender and racial diversity throughout. As a result of these audits, the company realizes that there are several teams within its sales departments that lack women and people of color. The company brings up this lack of demographic diversity to the relevant managers and encourages them to add more women and people of color to these teams. This sort of intervention makes complete sense for a firm that has embraced the business case for diversity. They need to increase demographic diversity of their teams to ensure the best value and profitability of the firm. There is a business problem and a business answer. Assign more women and people of color to the teams that are lacking in demographic diversity. But if this issue were reframed to also prompt one to consider ethical concerns, decision makers at the firm who are encouraging managers to restructure their teams might go a bit further to think through what the managers would need to actually accomplish these goals. For example, would the managers need to assign current women and people of color to more than one team? Would those women and people of color end up with more demands on their time than their white male counterparts? If they would that increase in team or committee work have a negative impact on the women and the people of color and their ability to complete other expectations and requirements? In other words, an ethical frame might encourage decision makers to think how their mandate might impact the people who would be expected to actually perform this additional work, and whether it would be helpful or harmful to them personally, instead of just focusing on bottom line concerns for the firm. Now let's reframe a legal case example. So when creating DEI programs, firms started off by attempting to create strong anti-discrimination norms and alter the demographic composition of their workforces by attempting to hire more women and people of color. The legal case was not, however, rooted, at least not initially, in creating equitable and inclusive organizations. This is perhaps not all that surprising because it is likely quite difficult to mandate goals like the creation of an inclusive environment for all employees. How do you define that? How do you get through that? We'll talk a little bit about that later on in the talk. And yet, a reframing of the legal case to include moral and ethical concerns might help a firm approach their legal obligations in a more expansive way. So take the Coca-Cola settlement discussed earlier in this talk. Part of the remediation effort at the firm involved reviewing the ways in which Black employees were treated differently than their white counterparts and addressing any pay disparities that might exist. Let's assume, for example, that after the claims were settled, the firm engaged in a review of its employees' salaries in an attempt to identify and rectify any disparities across racial or gender lines. If one is conducting a review of this nature from the frame of the legal case, one is concerned with addressing the legal liability that has arisen within the context of the anti-discrimination lawsuit that was settled. One would identify any employees whose salaries looked as if someone was underpaid due to their race or gender and increase it to a level more on par with those employees' white male counterparts. One might even attempt to put in salary tables that tied compensation to certain objective metrics in an attempt to prevent similar disparities and legal liabilities in the future. These would all be activities that might result from looking at the problem of pay disparities from the perspective of the legal case. If one, however, reframed the issue of pay disparities as not just a legal issue, but also a moral or ethical concern, one might take additional actions. For example, one might hire a consultant or establish a committee to see if the table meant to create objective metrics for setting pay might inadvertently entrench or be impacted by structural racism. For example, do people doing the same basic work for the firm, but with different educational backgrounds, qualify for different levels of pay? Or do employees working in traditionally Black geographic areas of the country get paid differently than employees working in traditionally white geographic areas of the country? Or do certain divisions of the firm tend to be racially homogenous, with Black employees working as, let's say, for example, janitorial staff, while white employees work as mailroom staff? And are there pay disparities along the different divisions, despite the workers having similarly situated educational levels and employment backgrounds? If we have those sorts of examples, you might end up with a different outcome if you add an ethical framing to our traditional legal case analysis. The upshot for both of these arguments is that while the business case, I should be clear, I am not suggesting that the business and legal cases should be thrown away. I'm of the opinion that they both serve value and that they're both providing value and that they're both serving important functions within larger discussions and strategies regarding DEI efforts. But these have been around for such a long time. We know that they're not enough. We know that more needs to be done. And I think that adding additional framing with regards to what are the ethical components that need to be considered while engaging in the business case or the legal case rationale is really important. So framing is one insight from behavioral ethics. Another concept from behavioral ethics that I want to highlight is a bit harder to describe in a pithy soundbite. But essentially, the concept tells us that we are all capable of acting outside of our ethical and moral understandings of what the right thing is to do. So the example I'm going to use here is we all steal the pen sometimes. So what do I mean by that? If someone asked you whether you are a thief, I'm going to assume that you're going to say no. And to push it a step further, if I were to ask you if stealing is wrong, I bet most of you would say stealing is not okay. But for purposes of this portion of the talk, let's assume that we are all people who, one, would never become thieves, and two, believe it is wrong to engage in theft. I'm also going to venture to say we have all stolen a pen. Maybe not in a strict criminal law sense, banana. I've taken something that doesn't belong to me and I shouldn't have since. Let's say you work as a restaurant as a server, as I once did. I spent a few years working at a local chain restaurant, and at the time, pens really mattered when you were waiting tables. They mattered because you needed to give it to the person who was paid with a credit card, and you give them the pen to sign their bill, and really importantly, to give you your tip. And I don't know why, but I feel like we had to have our own pens for some reason. On a busy Friday night, there was sometimes nothing as annoying as when customers would walk away with my pens. Now, you'd say it's just a pen, and surely it was an accident. The customers aren't thieves. I know they weren't thieves, but it was my pen. It was taken, and it mattered to me. It caused me stress. It caused me inconvenience. I had to then go try and borrow a pen from someone else. It was a whole thing. Now, most of the time, taking a pen is an accident, but sometimes it's not. For example, sometimes a server, in their haste to find a pen to use for Friday night, would pick up a nice pen. And sometimes people would take the pen that was provided them for the limited use of signing their bill at the end of the meal, so for one purpose, and they would realize they really liked the pen. Maybe it was green. Maybe this particular pen wrote super smoothly, or whatever it was. This customer, who is not a bad person and who is not a thief and who does not believe in thievery, has purposefully, not accidentally, taken the pen. And when they take it, they think to themselves, it's just a pen. It doesn't matter. Or they don't even think about whether or not it matters, because after all, it is just a pen. For purposes of our talk today, let's refer to what's going on in our pen example as embodying the reality that how we behave is more malleable than we think. And given the right set of circumstances, we can all steal the pen. Acknowledging that we often fail to meet our aspirations, ethical standards, and values is really important, because if we ignore when we are failing to meet a goal, we are very unlikely to make the changes necessary to actually achieve what we are striving for. The continued failures, after over 3 decades of work by corporate firms to create truly diverse, equitable, and inclusive organizations, suggest that they need to think deeply about why they have failed to achieve the goals they have set out for themselves as organizations. And so now I want to turn to building a culture of ethical inclusion. Now that I've explained a little bit about how behavioral ethics insights might be important to include in DEI conversations, I want to talk a bit more explicitly about inclusion. So inclusion is defined in a few ways. Merriam-Webster dictionary defines inclusion as, quote, the act of including someone or something as part of a group, list, etc., or thing that is included, end quote. Dictionary.com says, quote, the practice or policy of including and integrating all people and groups and activities, organizations, political processes, etc., especially those who are disadvantaged, have suffered discrimination, or are living with disabilities. The website Very Well Mind describes inclusion as, quote, the act or practice of including and accommodating people who have historically been excluded because of their race, gender, sexuality, or ability. I think these are great definitions of inclusion, but the one I like best is actually from the U.S. Department of Housing and Urban Development, which describes inclusion as follows. Inclusion is a state of being valued, respected, and supported. It's about focusing on the needs of every individual and ensuring the right conditions are in place for each person to achieve his or her full potential. Inclusion should be reflected in an organization's culture, practices, and relationships that are in place to support a diverse workforce. Inclusion is the process of creating a working culture and environment that recognizes, appreciates, and effectively utilizes the talents, skills, and perspectives of every employee, uses employee skills to achieve the organization's objectives and mission, connects each employee to the organization, and encourages collaboration, flexibility, and fairness. They define inclusion as a set of behaviors or culture that encourages employees to feel valued for their unique qualities and experience a sense of belonging. This definition, I think, best reflects what I think of when I think of inclusion, or what I hope inclusion will be. So let's go back to the argument I outlined at the very beginning of this talk. I said, when I focus on a culture of ethical inclusion, I am concerned about how organizations can create cultures where people of diverse demographic groups and varied belief structures are able to interact and work together while maintaining the inherent dignity of each person. I spoke earlier about increasing demographic diversity and how management scholars have said that that's not going to be enough. And I agree with that. Increasing demographic diversity on its own will never be enough. But if you don't have any demographic diversity, the quest toward DEI initiatives is not starting in a great place. So it is a really important component of all DEI efforts and to getting to an environment of inclusion. So first we need to find our diverse demographic groups. And if we don't have some, we need to figure out how do we increase demographic populations within our organizations. And then we have to focus on how we deal with varied belief structures. This, to me, is one of the most fraught conversations we can have today. I think we are operating in a particularly difficult political environment where it is incredibly hard to have nuanced and fulsome conversations with people who we don't agree with at our core. And organizations and management within organizations have to deal with this each and every day, just like law schools do, just like law students do. And it's really important to figure out how folks of different demographic groups and varied belief structures are going to interact and work together. Because at the end of the day, we take a whole bunch of people from all sorts of backgrounds and places in life, and we put them together into an organization. And we have to figure out how to create a culture that allows each of these individuals to thrive. And you can only do that, I think, if you allow each of those individuals to be valued for their diverse perspectives and identities, while allowing them to maintain their individual dignity. And this is super challenging. I'm not suggesting that this is something that's going to be easy, because it's not, as evidenced by the fact that corporate firms have frankly just failed to do this for the last 30 years. After I laid out that initial argument, I then said we can only achieve such an outcome, so building a culture of ethical inclusion, if we are willing to actively frame issues of DEI as ethical issues while also taking into account that we all sometimes fall short of acting in accordance with the ethical standards and values that we expect of ourselves and others. This latter sentence has been what I've been trying to communicate during my remarks. We must reframe conversations about DEI as ethical questions, not just business and not just legal and certainly not political. But in doing this, we must humbly consider the ways we will fail to address those failures head on. Because achieving the ethical standards and values we set for ourselves, regardless of the underlying topic, is always a fraught task. Just in conclusion, I'd like to say to the law students who are here today, I challenge you to think about how you can create a culture of ethical inclusion at your law school. Law schools, law students, and legal educators are poised to make really important decisions right now about how law school cultures will persist with traditions of the past or transform to new pathways that will lead to more inclusive environments. As schools like your own are doing things like pulling out of the US News rankings, and as the ABA has made the LSAT optional for accreditation purposes, law schools are at an important inflection point. What will we decide to do with this opportunity? Will we evaluate whether we are doing things because they are the best strategic choice for our students in our world? Or are we doing things because that's how it's always been done? And so for the students, I really want to challenge you to think how you might reframe your thinking about what it means to be inclusive. And I encourage you to move away from debates about politics or affirmative action or racial preference or quotas to conversations about ethics. How should we treat our classmates, and our colleagues, and those who want to seek our ranks? And to think about what steps you personally and purposely can take to make your communities, the realization that your community includes your family, your friends, your workplace, your neighbors, and beyond, more purposely inclusive spaces. That's what I mean, at least in part, by building a culture of ethical inclusion, I'm reframing the debates about what we need to do to create a more equitable society for Black people, women, people of color, the disabled, from political or legal or business decisions to questions of ethics. Because at the end of the day, I believe that most individuals' internal beliefs do not align with concepts of discrimination or superiority or privilege. They are more aligned with acceptance, community, and grace. But we don't just get to the world of our ethical goals and values without doing a whole lot of work. We must be active and purposeful in thinking through the steps we can take to align our internal belief structures to the world in which we live. Thank you so much for having me speak to you, and I look forward to your questions.
Well, thank you so much, Professor Martinez, and just for your expertise and for talking about something that we can apply to all of our lives. I wanted to just remind people that we have a few minutes, about 10 minutes left for questions. If you could please, in the chat function, send those questions directly to me, Carla Meyer. I'll start off because Dean Afsharipur has sent a question already, and this is her question for Professor Martinez. What role should firms, general counsels, and legal departments have in advancing DEI among the leadership at firms? How should they advance an ethics case?
So this is a really interesting question, and we can use Coca-Cola as another example. So the Coca-Cola's had a range of general counsels after different things that have occurred at the firm. That part of their role has been to address DEI issues. And there was a general counsel at Coca-Cola a couple of years ago now, maybe the last year or two, who was sending really strong pressure to big law firms. They needed to diversify to increase the demographic diversity of their legal teams, or he was going to pull back the business. And that's kind of not a new threat. So there have been a number of initiatives over time where groups of corporations have signed statements and said that they were going to do this. But we are seeing kind of more teeth to some of that more recently. Now, the irony for the general counsel at Coca-Cola was he was pretty quickly, he was pretty quickly no longer the general counsel of Coca-Cola, I guess is the way I should put it, which would suggest that there was tension within the organization about some of what was going on at the firm. And I think one of the things to think through is how we as lawyers can be leaders within organizational environments. The Deborah Rohde, who recently passed away, had done a lot of research on lawyers as leaders. And we are, as lawyers, poised to advise our clients in a way that does suggest to them that we are in a good position to advise our clients to think expansively about the sorts of priorities they should have and the sorts of liabilities that will arise if they don't focus on certain things. So Model Rule 2.1 talks about the lawyer as advisor. The lawyer as advisor is not something that's meant to be narrow. The lawyer as advisor says that you should be advising your client on legal issues, but on moral issues, ethical issues, and that we should think of our counseling role really expansively. And so I think general counsels are in a really important position to increase diversity within the firm itself, but also with their external partners by how they adopt their certain policies. And we are seeing some ways in which these sorts of initiatives are impacting at least the legal profession.
Thank you so much. There's this question comes from, I believe, Sharon or Shireen, and can you please speak to how microaggressions that lack malicious intent would fit in with ethics and open dialogue?
So one of the if you read Acting White by Devin Crombato and Mitsu Galati, which is not a new book, it's been around for a while. Part of what they're discussing is the ways in which Black employees don't feel comfortable being their full selves within the workplace, and that Black employees are having to cover certain aspects of their identity when coming into the workplace. When we think about the way, there are all sorts of ways in which we can feel like we are being devalued because of comments or statements others make. And part of the key for an organization is to figure out when those moments are happening and how to properly address them. So much of what we within the legal profession have done within the, let's say, the employment discrimination and harassment space has been focused on particular legal standards. So we've literally taught human resources departments, this is what is legally impermissible and this is not, and then this doesn't meet the threshold of legally impermissible. And there are reasons we did that. One, that is the law, and so we're training the human resources on the law. Another one is that anytime you adopt a standard that is above the legal threshold, you increase your zone of legal liability. And so firms have incentives to not create standards that are above the legal threshold because they are then opening themselves up for additional liability. I think this is a mistake by lawyers. I think that when we focus just on legal liability and not on what the right thing is to do, we are in fact creating a whole set of other risks for the firm, even if we don't realize how we're doing it. So if an employee is experiencing a lot of microaggressions, they don't have to stay there. The cost of replacing employees is incredibly costly to replace employees. If we're only focused on legal liability in the sexual harassment space, and then another Me Too movement comes along, guess what? It doesn't matter whether or not it was severe and pervasive under the federal court standards. A lot of this stuff, when it comes out into the light of day, is just obviously wrong and unethical and shouldn't have been tolerated within the organization, even if it didn't meet the strict definition of what counted as severe or pervasive. And so I think it's really important for firms to not just think about what is my legal obligation? What do I have to do to comply with legal and regulatory mandates? But also to think through, and what sort of organization do I want to be? What are my aspirations? What are my goals? What is the culture that I'm trying to create? And you really have to go and look at that. So there's a strand in behavioral ethics that says if you tolerate small amounts of misconduct, you're going to get more. That's pretty similar to some of the economics literature as well. But anyway, so if I'm okay with small amounts of harassment, even if it's not legal sexual harassment, if I'm tolerating small amounts of harassment, I'm going to get more. If I'm tolerating certain types of microaggressions, if I know about them and I'm not doing anything, I'm going to get more. That problem is going to grow and get bigger. Additionally, there's another strand within management literature about the importance of voice and the damage of silence. So legal scholars often talk about Hirschman's exit voice loyalty piece. But within management literature, there's a much more robust set of discussions about the damaging effects of employee silence. If people don't think that an organization is going to respond to microaggressions, the employee is not going to complain. And when an employee chooses silence, they're very unlikely to be happy to have good job satisfaction. They're not just going to be silent about the microaggression. They're also going to be silent about things that matter in other aspects of their job. And so that's a really not ideal culture to create. And so I think it's important for firms to think, what are the goals we are trying to set? What's the culture we're trying to create for ourselves? And use that as a metric as opposed to just what is legally permissible or not. Because there's a whole bunch of risks that come with just thinking through a legal framework.
Thank you so much. And we are about out of time for questions. I wanted to thank you so much, Professor Martinez. And I'm going to give it back to Dean Afsharipur.
Thank you so much. Please join me in thanking Professor Veronica Martinez, both for this really enlightening conversation and also for the great scholarship that she has done in this area that I think has really advanced our thinking about how to truly build a culture of inclusion. So please join me in thanking her.